Well, hello and welcome. Yes, I am back. I don't know how long I'll be back for, but yes, I'm back for now. How are you? I know there's been so much that's happened. Welcome to the train wreck. I know people are also waiting for my breakdown of the Brittany Higgins, Linda Reynolds stuff. That's gone into a little bit of crazy town. Hi, Kato. That's also gone into a little bit of crazy town as well, because Brittany Higgins has actually filed an appeal in that decision, and Linda Reynolds has started bankruptcy proceedings against Brittany Higgins. So that's one train that we'll be catching and having a look at. But I know that I'm somewhat late to the party, nearly 10 days late, and that's okay. I haven't seen the stuff. I have been, doing real life stuff that happens, when you have multiple things to do in life. Going to have a look at this here. This is the latest. So we have got, this is the case file at the moment. So we got to the fact that there was a responsive motion. Okay. So this was all the stuff that was filed on the 5th of the 5th of the 9th. And then on the 17th, oops, 17th, a whole pile of documents filed on the 17th. Then we get to the 18th. There's been a whole pile of stuff taken on the 18th, which is combined in a hearing that will take place. Hello, Renelle. That will take place later. So the hearing, I think, is on the 17th of the 10th. So that's coming up. Now, this hearing is for the document that has been filed by 7M, which is an injunction. Now, I have not seen any of this. I've read some stuff on social media, and I know that Miss Joy has been really annoyed about it. And I also, and there's also a response to, which we expected to have. There is a response back to the documentation regarding the motion. So let's have a look at this. So we're going to do this step by step, I think. Had all these tabs open, but I've sort of got them all lost a little bit. So let's do this a little bit. We'll go through. I'm going to open each document separately as it happens, or as it is, and we will go from there, I think. I'm actually free most of today, which is why I'm here. Okay, so we have got this notice of motion and motion. So the parties here. So let's have a look at this one here. We are going to open this. Thank you, Renelle. So I'll do my best. I've not seen it, so this is all you're going to get my first reaction, and it will be exactly as you'll get the reaction live. It'll be a live reaction, hey? So let's just look at this. Now, I just thought it was an injunction. So it says the plaintiff's notice of motion and motion for temporary injunctive relief. Now, without looking at the information, I am suspecting that this has got something to do with all the stuff that she filed about the arrest, or the stuff about Robert Shin and the raid. That's where I'm going with this. That would be my first instinct. We're going to find out whether my instinct is right. So on the Friday, the 17th October at 1:30 via Zoom, I believe it's been changed to in person, but that's all right. Plaintiffs do by him move the court at a time for an order for temporary injunctive relief. This motion will be based upon memorandum of law, affidavits, and exhibits filed, and the arguments of counsel and all other files and records of proceedings. Okay, so they have filed they are filing something what they call injunctive relief. Now, sometimes it is, it could be you can't talk about us, you can't talk about this matter. It can be a whole variety of stuff. Sometimes it's compensation. So this is an affidavit by, okay, and if you actually have a look here, it says other miscellaneous. So it's a different type of motion. So that this affidavit is made in support of plaintiff's memorandum in opposition of defendant's motion for consideration. And Exhibit A. Oh, yes. So that was from the last one. Okay. Oh, wait. Sorry. I downloaded the wrong one. Silly. There was so many files here. Sorry. I've opened up the wrong one. That was from the last one. See, we all make mistakes, right? Okay. Let me look at this one. Here we go. Memorandum for temporary injunctive relief. Here we go. This is 25 pages long, by the way. This is 25 pages. So I'll make this big, and so we can read it along together. So if I can close this box. This box is annoying me a little bit. Hide this bar, yeah. Okay. So this is their memorandum. Plaintiffs 7M Films, Inc., Robert Shin, Miranda Derrick, and James Derrick, collectively plaintiffs, respectfully request that the court grant their motion for a temporary injunction motion enjoining defendants Katie Mansky-Polson, also known as Katie Joy, and Without a Crystal Ball LLC, collectively the defendants, from making any public or online statements about plaintiffs during ongoing litigation. Since June 2025, defendants have made a dozen of public statements falsely accusing plaintiffs of serious crimes, including sex trafficking, fraud, forced labour, and other criminal conduct, none of which have resulted in any charges, much less convictions. These unfounded allegations have caused significant harm to plaintiffs' reputation and business interests and have included misrepresentation of this court's rulings. Plaintiffs contend that this conduct will continue absent court intervention, and the Dalberg factors Minnesota courts use to analyze whether injunctive relief is appropriate weigh strongly in favor of granting plaintiffs temporary injunction. For the reasons outlined above and fully set forth in plaintiff's motion and supporting papers, plaintiff respectfully asks the court to grant requested temporary injunction in this entirety. Now, you will have remembered when we went through the motion for consideration that Jennifer Moore had listed about the raids and everything. Now, what's really interesting about that is that they were bringing in new information before the court that was not, that they were referring to information that was not before the court. Now, what's happening now is that 7M is asking for an injunction to stop her from talking about it, and he's now going to bring some of that evidence in before the court. Regardless of whatever you think about Robert Shin or whatever, the house was raided. As far as we are aware, and today, I cannot find anything about any convictions or charges or anything. And so under the presumed innocence until proven guilty or found guilty, this is really what they are using. This will be this could actually play in 7M's favor. And just having a look at point 2, it says, before we're just going to scan down to point 2, she's talking about, they're referring to the video where she's talked about her shocking legal victory, how she's won. So this is really going to be interesting, because now all this evidence now is going to be put before the court. It doesn't necessarily mean it's going to be used to make the decisions against defamation, but it is actually proving 7M's case that she's talking about. It's doing further to enhance their case, that the more she talks, the more their business is being harmed. This could work really well for tortious interference. I'm okay, Bella. How are you? So it says on or around June 24, and don't also forget that Katie Joy's been on lots of different media outlets. She's been, doing the media rounds. So her income and stuff is definitely growing because of these things that she's been stating. So again, we get into the question, is her making those allegations about these about the raids, for example, is that defamation? And if so, what damage is there? So it's a really interesting thing, but what they're wanting to do is they're wanting to stop her from talking about anything to do with them while this is being pursued. Okay, so on or around June 24, 2025, defendants posted a YouTube video titled "The $10 Million Lawsuit Against Me Just Collapsed." This is huge. Falsely claiming that this court's denial of summary judgment meant that she would not have to pay $10 million to plaintiff. See Stavic Affidavit Exhibit 1. In the video, Katie Joy called this lawsuit frivolous and baseless and claimed plaintiffs had filed so much at the judge to confuse them. Katie Joy further states she has dozens of clips of plaintiffs she describes as evidence that she will be able to use if we go to trial, none of which have been disclosed to the plaintiff through discovery. That is the point. She can be sitting on a truckload of evidence, but if it's not discovered or not put before the court, it's unlikely to be able to be used, because one of the things that happens in court is that you have an opportunity to respond to any allegations before you. Hence why they are doing it via a motion where Katie Joy gets to respond to all of these allegations. Remember, they are allegations, all right? Allegations. And again, the court does not like it when there's, when there's talk like that, particularly when they have to make decisions and not everything is before the court. If you've got stuff that needs to go before the court, you need to get it into the court, even if you have to file motion. All right? But for her to say that on a public arena, yes, if they don't get a chance, if the other side doesn't get a chance to respond, it's viewed as unfair, unfair. So this is interesting. So now all of her words are being put into the court. On or around July 18, 2025, defendants posted a YouTube video correcting this court's recent ruling. Oh, sorry. Yes, we did that, didn't we? Oh, no, that's right. Yeah. Recent ruling on their motion for reconsideration as a shocking legal victory. Claimed it changes everything. Katie Joy described this lawsuit as frivolous from day one and asserted the court got it wrong. She further said this means that the court really likely got it wrong, and it's likely this case could get completely tossed. Katie Joy also asserted that the plaintiffs have provided no evidence of damages and lied during their depositions, and accused this court of ignoring her evidence. Furthermore, Katie Joy misrepresented the basis of plaintiff's tortious interference claim, specifically denying any role in public efforts to contact business partners such as LA Clippers. She also attempted to justify her repeated references to trafficking and cult in connection with plaintiffs by claiming such language was protected rhetorical shorthand and opinion. Hi, short order. She has framed this litigation as harassment and claimed without basis that the plaintiffs are attempting to confuse the judge and overwhelm the court. Now, this is going to be interesting because I am going to make the assumption that they've got the video downloaded. How on earth is Katie Joy going? How do you defend this when it's a video? And it's more than likely the court's going to have to sit through and watch it. How do you backtrack on this? This is what is going to be very interesting. On or around July 19, 2025, defendants posted on Instagram claiming a shocking legal victory and asserted that this court's ruling on their motion for reconsideration of summary judgment changes everything. Katie Joy stated this court may have gotten it wrong and criticised this court's reasoning as dangerous while promoting hashtags like trafficking, forced labour and cult as protected opinion, and discussed the ruling alongside unrelated public figure litigation. On or around July 25, 2025, defendants falsely posted on Instagram that law enforcement arrested plaintiff Shin in connection with alleged sex trafficking ring, further claiming that she'd spoken to multiple people impacted and harmed by it. Katie Joy asserted that plaintiff Shin and his followers had been stopped from harming anyone else, and paired the posts with defamatory hashtags such as sex trafficking, crime, cults, 7M TikTok films, falsely implying the plaintiffs are engaged in criminal conduct. I'll just stop there. We don't know. There's been, as if I'm wrong, we don't know what the raids were for. Is that correct? It's not come out as to what the raids were for. Who is overwhelming the court? Yes, short order. What? This is going to be interesting. It's a shame it's not on Zoom anymore because I'd love to be able to. I'd love to have been able to watch this. So we're up to point 5. The same day, defendant posted on her Instagram story accusing Shirley Kim of coaching plaintiffs Miranda and James Derrick to lie during depositions and claimed they were terrified prisoners. Defendants further alleged that Miss Kim abused and trafficked dozens of women into the bed of Robert Shin and his male followers, while asserting that plaintiffs Miranda and James Derrick lied and played dumb under her influence. Katie Joy included defamatory hashtags such as sex trafficking, money laundering, FBI, cults, Robert Shin, falsely implying plaintiffs' involvement in serious criminal conduct. On or around July 25, 2025, defendants posted a YouTube video falsely accusing plaintiff Shin of operating a criminal enterprise involving sex trafficking, money laundering, tax evasion, mail fraud, and forced labour. Katie Joy publicly asserted that this case will be thrown out because plaintiff Shin is under investigation by FBI. Katie Joy stated that plaintiff Miranda is being trafficked for labour and or intimate non-consensual contact with Robert or other men in the group. After stating, I don't know if the deposition transcripts are still listed as confidential or not, Katie Joy portrayed plaintiffs Miranda and James Derrick as terrified, coached and lied during depositions, and that they were not there on their own will. She states plaintiffs are under investigation for sex trafficking and it's only a matter of time before arrests are happen, and states, Robert Shin, your day is coming. On or around the 26th of July, 2025, Katie Joy declared she hoped plaintiff Shin dies in prison, claiming that she'd spent nearly $200,000 defending herself for reporting on victims of his alleged abuse. What are your thoughts so far on this? I mean, it's very thorough. The same day, defendants posted on Instagram mischaracterizing plaintiff Shin court testimony by stating, given he admitted that members of his church were physically abused, and he claimed to have sex with many women in the church and provided them housing jobs. He even told the court, I am not a sex trafficker. Yeah, okay, Roberto. Defendants paired this statement with defamatory hashtags such as sex trafficking, labour trafficking, false prophets, Robert Shin cult, implying guilt despite acknowledging plaintiff Shin's denial of trafficking. Defendants also posted that plaintiffs Miranda and James Derrick had a fake marriage, claiming Miss Kim filed a questionable marriage license over a year after the couple's claimed wedding date, implying intentional deception. Haven't we already gone through all of this? Hasn't, like, it's quite, I've just got no words. She's had to backtrack on the wedding stuff, and here she is poking the bear again. Defendants accused third-party Alison Holker of enabling the sex trafficking cult by publicly supporting the plaintiffs. Defendants also posted that discovery materials provided by plaintiffs in this case revealed forged taxes, marriage license, and business contracts, which she claims proves plaintiff Miranda Derrick had no control over her life, marriage, and finances. She further stated that she spent $200,000 defending herself to expose plaintiff Shin as a predator and help free his victims. Now, I'm going to just pause here. Now, remember that there is quite a few of these documents that were for lawyers' eyes only. Now, has she just broken lawyer-client confidentiality by talking about the fact that she's seen it? So let's just say, for example, that those taxes and finances were lawyers' eyes only. If she's talking about discovery materials that were confidential and can't be talked about, she's probably breached lawyer-client privilege. So therefore, her lawyers would have to then would be then obliged, because they are representing they ultimately represent the court at the end of the day and justice. They would be obligated to tell the court what they actually told her, and possibly, if they have breached the confidentiality clause by the court, could actually risk receiving sanctions by the court. We don't know what documents were for lawyers' eyes only, and because we don't know that, this is just speculation. But it's a very big, if she has done that, they're not going to say protected by client lawyer privilege. She's been bragging that she knows what was happening in all of these things. And so if she's saying, I know what discovery and they had forged taxes, if that was under seal for lawyers' eyes only, and she's now declaring that the taxes were, for example, forged, she could only have got that information from her lawyers. So she has probably thrown her lawyers under the bus. Just think about that for a moment. As I said, it's just speculation, but this is really where it could possibly go. And as I said, look, if the lawyers have to take an oath to tell the truth, they won't be protecting Katie Joy. They actually have an obligation under their license to do right by the court. So they will have to spill their guts, so to speak. And but if the client has actually released released privileged information from the lawyer, then it's open slather. What I see is KJ basing all her stuff on an old lawsuit and the one that hasn't happened yet, from those with an incentive of $4 million payout if they win. Am I right? That yes, I think so. Yes. Okay, so then we're up to point 12. Katie Joy posted that she'd spent $200,000 fighting plaintiff Shin in court and declared she will never settle because she knows he is guilty. Defendants accused plaintiff Shin's CPA of fraudulently preparing tax returns for him and his followers. Again, she can accuse, but it's only alleged, and there's maybe the evidence is sealed, but I've not seen any evidence. Katie Joy posted that plaintiff Shin's alleged traffickers claim it's all a misunderstanding. Defendants posted that plaintiff Shin has been caught and will go to prison, implying guilt when no charges have been made. Katie Joy alleges with 90% confidence that plaintiff Miranda Derrick's signature on a marriage license is forged, accusing plaintiffs of falsifying legal documents. 90% confidence, that's a big thing. Katie Joy posted that she's been calling out traffickers for 3 years and 5 months, repeatedly accusing plaintiffs of illegal trafficking activities. July 27, 2025, Katie Joy claimed she met with the FBI and helped initiate an active investigation into plaintiff Shin and provided detailed information about his alleged misconduct. Katie Joy alleged that Shekinah Church members left in 2022 after participating in trafficking and fraud under plaintiff Shin's control. Defendants claim to have gathered evidence over 3 years to expose plaintiff Shin and is willing to testify and cooperate with law enforcement. A defendant's post stating we are trending a day after the raid accuses plaintiff Shin of forcing female followers into sex with business clients to secure deals or celebrity meetings, alleging coercion and sex trafficking. On or around July 28, 2025, defendants posted a YouTube video stating plaintiff Shin funneled non-profit church funds into a profit business, committed tax evasion, human trafficking, forced labour, sexual abuse, fraud, and controlled followers who live in modern-day slavery, though no charges had been filed against him. Katie Joyce stated that plaintiff Shin uses women for sex and forced labour, stating they are basically slaves, or showing photos of plaintiffs Miranda and James Derrick. Katie Joyce stated plaintiff Shin is running a criminal scheme and that's where they're going to get him. So I'm also... I'll just pause there again. We're just pausing just to let all of that sink in. The other thing is that I don't know. We're at page 6 of 25. I wonder whether they're going to mention that she's been doing the rounds of media and all these interviews. On or around July 29, defendants posted an Instagram story advertising her new YouTube video titled "Executive TikTok Cult Leader Robert Shin's Laundry Lists of Crimes Exposed," again asserting criminal conduct without any formal charges being made against plaintiffs. The same day, defendants publicly pressured a brand partner, Drink Prime, to sever ties with plaintiff James and Miranda Derrick by associating them with uncharged alleged crimes involving plaintiff Shin, and asserted that influence income is funneled to him despite no judicial findings. Oh, here we go. We got it. Point 25. So after saying that she denied that she interfered with the brand, point 25 now talks about her on her TV appearances. Katie Joy promoted her national TV appearance to discuss plaintiff Shin on her Instagram story, asserting members are in danger as long as he's free. On News Nation's Banfield Tonight, a national television show, Katie Joyce stated as fact that plaintiff Shin committed tax fraud, sex trafficking, and labour trafficking, identified individuals as his deputies in a criminal scheme, and claimed members are abused and in serious danger without using terms like allegedly or clarifying the absence of criminal charges. The news host, Laura Engel, was compelled to clarify that there are no charges against the plaintiffs. Defendant then posted a video clip of Katie Joy's appearance on News Nation's Banfield Tonight, publicly discussing the plaintiffs on Instagram. Later that day, defendants promoted Katie Joy's national TV appearance on social media, declaring her intent to keep fighting until victims are free, therefore implying plaintiffs are perpetrators of wrongdoing. Defendants posted that plaintiff Shin is dangerous, accusing him of labour and sex trafficking and running a pyramid scheme, despite there being no charges against plaintiff Shin. On or around July 30, 2025, Katie actively promoted her Banfield appearance on Instagram, urging the public to help spread the story wide and declaring no more hiding Robert, thereby monetizing and amplifying alleged damaging allegations against plaintiffs. I'll pause here. It'll be interesting to see if this injunction is upheld, but this is all evidence as far as damages is concerned. This is all. But the other thing that it also shows is that she's doing the same things over and over again. It's repeated behavior. Some of the stuff that have been alleged in the original claim have all come back again. Have you noticed? So point 31. Katie Joy posted that Miss Kim is accused of coercing members to gain access to their bank accounts, then draining funds to benefit plaintiff Shin, forging signatures, filing illegal documents, imposing strict diets, engaging in verbal abuse and physical aggression, labelling Miss Kim as a monster. On or around July 31, 2025, defendants accused plaintiff Shin of controlling and endangering individuals through a sex trafficking cult, saying, "I have spent 3.5 years fighting for victims of an alleged sex trafficking cult, vowing I won't stop until Robert Shin is in prison for life and all of his victims are free," and asserting that plaintiff Miranda Derrick is in danger. On or around July 31, 2025, defendants posted on Instagram, "People's lives are in danger and women are at risk of being trafficked by this cult." So again, I'm just going to pause there. Now, don't forget, you can be found innocent of criminal offences and guilty of civil, because the standard of proof is different. So in criminal charges, you have to have beyond a reasonable doubt. In civil, it's on the balance of probability. So often it is easier to get civil things through than it is to get criminal through. So it could be, and there's a very good chance that there's not enough evidence for any criminal charges, for example. And then just because you're at the civil burden does not necessarily mean that you are guilty. I mean, the most famous one is O.J. Simpson, all right? If you think of that, he was found not guilty at the criminal standard, but he had to pay compensation at a civil standard. And that is whether he did it or not, we can debate that till the cows come home. He knows whether he did it or not. But at the end of the day, there was not enough evidence. And he, as far as the laws was concerned, was not guilty. Okay, so just bear that in mind, that the civil standard is based on the balance of probabilities. The criminal standard is beyond reasonable doubt. Okay, if there's 1 ounce of doubt, I want to know who contacted Banfield to put this front and center. I have a feeling it was KJ. Why would the show pluck her out of obscurity? They wouldn't. Yeah, I mean, and why? I mean, and the other thing is, why her? Why not Melanie Lee? Or why not one of the real victims? Or why not have Miranda's family? You know, wouldn't they be better? But yeah, it's just really want to. If KJ contacted them, it was tactical. At that stage, she had nowhere else to go, and the timing of the raid. Correct. Guess who's calling me? The same person that calls me every time I'm live. All right. So post 34. On or around August 11, 2025, defendants posted that James and Miranda Derrick deleted Insta and TikTok, alleging plaintiff Shin has a history of deleting evidence and scrubbing the internet. Defendants posted that dancers' social media profiles directly benefit plaintiff Shin financially, and that continuing content creation would be equivalent to committing crimes amid an FBI investigation, implying wrongdoing without evidence or formal charges. That same day, defendants posted on Instagram accusing plaintiffs of deleting evidence by removing Instagram and TikTok. Now, we all know that you can actually deactivate those without losing any evidence. We know that, right? Alleging on or around the 12th of August, 2025, Katie Joy posted a public invitation on Instagram stating, "Catch me tonight in Banfield tonight to give an update on federal investigation of plaintiff Shin and why plaintiffs Miranda and James Derrick's social media are now deleted," thereby using Instagram to monetize the controversy by promoting her coverage and further spreading the plaintiffs. While on Banfield, Katie Joy claimed that plaintiff Miranda and James Derrick's radio silence following trials and deletion of their social media accounts is part of the pattern plaintiff Shin uses to delete evidence. While facing legal scrutiny, and emphasized the loss of plaintiff's substantial social media following, therefore making defamatory statements that damage plaintiff's reputations. Katie Joy stated the hope is that he'll go to prison for life, and the news host was compelled to clarify if he's guilty, but right now he's not even charged. I mean, you want to call yourself a journalist? I mean, it's interesting that the host on Banfield tonight is having to clarify that, you know, he's not being charged yet. But if she's saying that he'll go to jail, I mean, it sounds like she's implying by fact. On or around the 13th of August, 2025, Katie Joy posted a message directed at plaintiffs Miranda and James Derrick, urging them to come home and leave, while publicly calling on US attorneys to please indict and arrest Robert Shin, and declaring, "We won't stop fighting until everyone is free and Robert Shin is in prison," therefore making defamatory statements implying plaintiffs' involvement in criminal activity without proof. On or around August 19, 2025, defendants posted that plaintiff Shin is subpoenaed by a federal grand jury and that a federal indictment for multiple criminal charges could be imminent, while acknowledging that Shin denies all allegations in the civil trial and maintains his innocence. noting that the attorneys also represent plaintiff Miranda Derrick as a witness, suggesting reasons for her social media deletions. These statements, despite no arrests or formal charges, further propagate defamatory implications against the plaintiffs. On or around the 20th August 2025, defendants posted on Instagram accusing plaintiffs of willfully defying multiple court orders to produce financial records and claiming that the plaintiffs' attorneys had failed to respond for almost a month and abandoned the case. Katie Joy further claims that one of the plaintiff Shin's many victims, Katie Joy further claims that she's one of plaintiff Shin's many victims. She expressed hope that plaintiff Shin would be arrested and indicted, and the judge throws out this case against me. How is she one of the victims? Is she saying that he's trafficking her? Katie Joy further claimed that she's one of plaintiff Shin's many victims. As at the date of filing, no criminal charges have been made against plaintiffs. So there's been no charges, as I said. Now, I believe that since all of this has been filed, she's done another Instagram rant. So that could be done. I imagine all of that those further posts will be put into court as evidence. And also remember that the others, like 7M and the Derricks and Shin, have not responded, and they've just maintained silence as well. You just remember, if you let somebody keep talking, they usually dig a hole for themselves, and they're just letting her go. The court should grant plaintiffs' motion for temporary injunction, as plaintiffs will suffer irreparable harm for which no adequate remedy at law exists, absent such relief. Monetary damages are insufficient to fully address the continuing harm to the plaintiff's reputation, relationships, and business interests. Furthermore, the Delberg factors weigh heavily in favour of granting plaintiffs requesting temporary injunction. That's interesting. Yes, so they're saying no amount of money will actually solve this. The only way that this can be solved is by her keeping her mouth shut. And this is what this is. This is what this will end up doing. She will be forced to. She won't be able to talk about it. Temporary injunctions are governed by Minnesota law. That a temporary injunction may be granted if by affidavit, deposition testimony, or oral testimony in court it appears that sufficient grounds exists. To obtain a temporary injunction, the applicant must show that no adequate legal remedy exists and that the injunction is necessary to prevent irreparable harm. The purpose of a temporary injunction is to preserve the status quo until the case is decided on merits. The applicant must have a valid underlying course of action. The applicant is asking the court to preserve the status quo until trial. So that's the legal grounds, and they're saying plaintiffs will suffer irreparable heart injury if relief is not granted, of which there is no adequate remedy at law. For a court to grant a temporary injunction, the first step is to determine whether a requisite threat exists. The threatened injury must be real, substantial, and irreparable. Irreparable harm exists where no adequate remedy, typically because monetary damages cannot fully compensate for the injury. And again, it's all supported by case law. The irreparable harm must be established by verified affidavits or pleadings. Minnesota courts have recognized that loss of business and customer goodwill can constitute irreparable harm. Courts may infirm irreparable harm when a customer goodwill is at stake, again. And then this one, they said finding irreparable harm where a business lost clientele. Although not a binding and persuasive, Minnesota District Court decision held that social media posts causing business losses can constitute irreparable harm, justifying injunctive relief. Okay, so they've said that there is a precedent, but it's not a binding precedent as such, but it has been found that social media posts could. Here, plaintiffs face ongoing irreparable harm due to the defendant's sustained public misconduct, which cannot be remedied through monetary damages alone. Defendants' persistent and inflammatory social media activity has not only damaged plaintiffs' goodwill and business relationships, but also undermined the integrity of this ongoing litigation. Defendants have repeatedly publicly accused defendants of sex trafficking, fraud, forced labour, tax evasion, and other criminal conduct, despite the absence of any legal findings or formal charges against the plaintiffs. And again, they've put in the examples. These statements have been disseminated to wide audiences via YouTube, Instagram, and national television, and are frequently framed as statements of fact rather than opinion. Defendants have also encouraged brands, including Drink Prime, to cut ties with plaintiff and plaintiff's business activities to alleged crimes, therefore directly interfering with plaintiff's economic relationships. These repeated sensational accusations disseminated to millions cannot be undone through monetary damages alone. The damage to the plaintiff's reputations, careers, and business partnerships is ongoing, incalculable, and precisely the type of harm injunctive relief is meant to prevent. Therefore, plaintiffs will suffer irreparable harm if the temporary injunction is not granted. In addition, defendants have repeatedly misrepresented this court's findings, falsely claiming that this lawsuit has collapsed, that Katie Joy won, and that the court got it wrong, and that she won't have to pay $10 million to Robert Shin and James Derrick. Moreover, defendants criticised this court's reasoning as dangerous and discussed the ruling alongside unrelated public figure litigation, therefore publicly challenging this court and further spreading contentious statements. Defendants accused plaintiffs of lying under oath, coaching witnesses, deleting evidence, and forging documents. Furthermore, defendants claim that plaintiffs have all but abandoned the case. This mischaracterization of the court's rulings misled the public, undermined confidence in the legal process, further enhancement and reputational harm to the plaintiffs. The cumulative effect of this conduct is to interfere with the orderly justice and prejudice plaintiff's ability to obtain a fair outcome in this case. If left unchecked, defendants' continued dissemination of these false inflammatory statements poses a substantial and ongoing threats to plaintiffs' rights, reputations, and the integrity of this court's proceedings. Accordingly, plaintiffs' motion for temporary relief should be granted as plaintiffs will suffer irreparable harm if relief is not granted, for which there is no remedy at law. All right, thoughts, people. We've still got a long way to go. There are some very valid points in there, to be fair, that I really do believe that there are some very valid points that they've pulled up here. So very interesting. Okay, plaintiffs have satisfied the Dahlberg under Minnesota law. Once a proponent for a temporary injunction has established irreparable harm, the next issue is to conduct the Dahlberg analysis. The Dahlberg analysis applies multiple factors to determine if injunctive relief is important, including the relationship between the parties, the harm suffered to the plaintiff, if his request is denied compared to the harm suffered by the defendant if the restraining order is granted, the likelihood of success on merits, public policy, and the administrative burdens of enforcing the order. This analysis applies to temporary injunctions. Here, the facts of the case show that the majority of the Dahlberg factors clearly show support granting temporary injunction. It's sort of like a restraining order. They just call it an injunction. She won't be able to speak about them. So here is part A, the relationships between the parties support injunctive relief. The first Dahlberg factor considers the nature and background of the relationship between the parties pre-existing the dispute giving rise to request for relief. This factor is concerned with maintaining the status quo pending a decision on its merits. Here, there is no pre-existing relationship between the parties prior to this dispute. Defendants had no professional plaintiff before launching a defamatory social media campaign against plaintiffs. Defendants initiated contact through unsolicited defamatory accusations of criminal conduct and efforts to inferred with plaintiffs' business relationships. Therefore, the first factor favours plaintiffs as the status quo prior to this litigation involved no connection, communication, or public engagement between the parties. Restoration of the status, namely no comment or commentary, would serve the purpose of this factor. A short order says she should have to shut up. She's making it worse. She's validating every point that they make every time. She can't keep her mouth shut, and her commentators go on to do more. Who are these people? Yes, and her commenters. Yeah, that's right. So I tend to agree. I think she's making it worse. Okay, balancing the harms weighs in plaintiff's favour. The second Dalberg factor weighs the harm plaintiffs if the temporary injunction is denied against the harm to defendants if it is granted. The Minnesota Court of Appeals has identified this as the most important factor in deciding whether to issue a temporary injunction. Here, the potential harm to the plaintiffs gravely outweighs its potential harm to defendants. So here's the thing. If, let's just say, the status quo is maintained and neither side commented on each other, which is essentially what the status, what they want from the status quo. But the fact is one party is talking about the other side's remaining quiet. So it would seem that it would make sense that the judge rules that they don't talk about each other. That to me would be the most likely here. And what harm, would the harm by her speaking, is the harm to the plaintiffs or 7M, Shin and the Derricks worse or better by her talking? And it's worse. So I think they're going to meet the second factor of the Dalberg here. But anyway, here the potential harm to plaintiffs greatly outweighs any potential harm to defendants. Yeah, so what harm is there to the defendants? There's none, because they're not talking about her. Plaintiffs will suffer irreparable harm if defendants continue their false and defamatory social media campaign. Defendants have repeatedly and publicly accused plaintiffs of a laundry list of serious crimes, including sex trafficking, money laundering, forced labour, tax fraud, and despite no legal findings or formal charges against plaintiffs, defendants have urged the US attorney to indict and arrest plaintiff Shin, labelled plaintiff Miranda Derrick as in danger and controlled by a cult, accused plaintiffs of forging legal documents and deleting evidence. These false accusations have been broadcast widely on YouTube, Instagram, national television, reaching hundreds of thousands of viewers. The persistent defamatory conduct has caused severe reputational harm, loss of brand deals, and the collapse of key commercial relationships. For example, Katie Joy publicly urged brands, including drinkers with plaintiffs, directly interfering with plaintiffs' business relationships. The severity of defendants' statements has caused and will continue to cause irreparable harm to plaintiffs' business and customer goodwill, especially when distributed online to hundreds of thousands of viewers. So there's a case here at 3839 holding that an individual suffered irreparable harm when the opponent was using online platforms to accuse the proponent of sexual assault, pedophilia, and Satanism. So there's already been a case where those allegations have been found to irreparable harm. So, moreover, the plaintiff's irreparable harm is not hypotypical. Plaintiffs have already suffered severe reputational harm, damage, lost brand deals, and seen the collapse of key commercial relationships as a result of defendants' defamatory campaign. Defendants have recently publicly targeted plaintiffs' clients and implied criminal liability without any charges against plaintiff. The situation had become so severe that plaintiffs Miranda and James Derrick deleted their social media presence due to backlash from defendants' increased aggression this year. So this is why they deleted their social media platforms, because they were getting harassed. Plaintiffs will continue to suffer irreparable harm if the injunction is not granted. By contrast, defendants will suffer minimal, if any, from the issuance of a temporary injunction. Defendants must demonstrate substantial harm to bar a temporary injunction, which does not exist here. The temporary injunctive relief sought by the plaintiffs does not constitute an unconstitutional restraint of free speech. Rather, it is a limited restriction aimed at preventing the dissemination of false, coercive, and defamatory statements that directly interfere with the ongoing litigation and cause irreparable harm to plaintiffs. A persuasive Minnesota District Court opinion upheld a similar injunction where speech targets parties to a case and undermines judicial proceedings. So it's at 9, upholding an Australian order prohibiting public statements about the order's proponents. Preventing defendants from targeting plaintiffs' business or spreading harmful misinformation online does not constitute a substantial risk of harm. Therefore, the defendant is far outraged by the significant and irreparable harm to the plaintiffs continue to suffer in the absence of judicial intervention. Accordingly, the second Dalberg factor strongly supports granting the temporary injunction. Plaintiffs have demonstrated a likelihood of success on merits. The third Dalberg factor examines the likelihood that one party or other will prevail on the merits. A court errs in granting temporary injunctive relief if the proponent cannot show a likelihood of prevailing on merits. However, even a doubtful showing of success on merits may support injunctive relief when the other factors strongly favour the proponent. Noting that some obstacles to a plaintiff's case do not preclude a district court from granting temporary relief. Here, plaintiffs have far more than a doubtful chance of prevailing on merits. Plaintiffs are likely to succeed on their defamation claim. To establish a claim of defamation, the plaintiff must prove that the defendant communicated a defamatory statement to a third party. The statement was false. The statement harmed the plaintiff's reputation or tended to lower the plaintiff in the estimation of the community. Where a plaintiff is a public figure, an additional element must be shown, actual malice, meaning the statement was made with knowledge of its falsity or with reckless disregard of the truth. I will always state, hello, Laura, Fly Mum. Yeah, the 17th of October, short order. This is going before the court. I've always said that I've always felt that I'm not saying that she's anointed, that she has been deliberately giving out false information. I've always stated it was my opinion that it's a reckless disregard of the truth. That's been always my thoughts on this, which would meet the melody. But because, I mean, okay, so his property was raided. Well, there's not much of a story there, but if you start then putting in all these other things, then you've got an exciting story. And to me, that's a reckless disregard of the truth, because the truth is we don't know what the raids were for. You see? So here the record contains voluminous evidence that defendants have repeatedly made demonstrably false, defamatory and malicious public statements about the plaintiffs across multiple platforms. Defendants have publicly accused plaintiffs of sex trafficking, tax fraud, forced labour and operating a cult, all without evidence or legal findings. Defendants have stated as fact that Shin is guilty of a federal crime and should be in prison for life, asserted that Miranda Derrick is in danger and under coercion, claimed plaintiffs submitted forged documents and deleted evidence. Defendants frequently characterise these allegations as factual, insider-based claims based on evidence which have not been disclosed to plaintiffs through discovery. These statements go far beyond protected opinion and rhetorical hyperbole. Notably, on or around July 25, 2025, defendants falsely stated that plaintiff Shin had been arrested for his role in an alleged sex trafficking ring and asserted that he had been stopped from harming anyone else, despite no arrest ever occurring. Defendants have accused plaintiff's counsel of coaching witnesses to lie under oath and claimed Ms. Kim had abused and trafficked dozens of women into the bed of Robert Shin and his male followers. These inflammatory statements were publicly broadcast on Instagram alongside defamatory hashtags such as sex trafficking, money laundering, and cult. Defendants also publicly accused plaintiff Shin of running a criminal enterprise and declaring on YouTube and television that he was guilty of tax evasion, money laundering, and human trafficking, all presented as fact without legal finding or qualifiers. Additionally, defendants' own words demonstrate actual malice. On or around July 28, 2025, Katie Joy publicly accused plaintiff Shin of funneling non-profit church funds into for-profit businesses, committing tax evasion, human trafficking, forced labour, sexual abuse and fraud, and maintaining control over followers whom she described as living in modern-day slavery, despite the absence of any criminal charges against him. She further alleged that Plaintiff Shin uses women for sex and forced labour, and stated that these women are basically slaves, while displaying photos of Miranda and James Derrick on screen. These inflammatory statements are not only demonstrably false, but they were made with actual malice and in reckless disregard for truth. Oh, there you go. I said it. Moreover, plaintiffs have specifically requested through discovery that defendants produce any evidence supporting these serious allegations. And then they've listed that it was produced first set of interrogatories and to date defendants such evidence or to demonstrate the defendants have any personal knowledge of the alleged facts underlying her claims. So who is it that hasn't submitted documents? All right, so we're going to keep going. Moreover, Katie Joy has repeatedly stated, I will not stop until Robert Shin is in prison for life, and has framed her conduct as part of a self-proclaimed mission to free victims, because women are being at risk of being trafficked by this cult, regardless of the legal process or evidentiary standards. On national television, defendants asserted that Plaintiff Shin and his associates were guilty of trafficking and other crimes, prompting the host to clarify that no charges had been filed. The persistent targeting and publication of damaging claims without factual basis further strengthens plaintiffs' likelihood of success in establishing defamation with actual malice. Moreover, defendants ignored the absence of any law enforcement action or formal charges and instead recklessly continued to accuse plaintiffs of criminal conduct, both explicitly and by implication, in a manner that satisfies the legal standard for defamation and supports a finding of actual malice. Therefore, the plaintiffs have a likelihood of success on their defamation claim, which weighs in favour of granting a temporary injunction. Plaintiffs have a likelihood of success on their defamation per se claim. Plaintiffs are also likely to succeed on their defamation per se claim. Statements are defamatory per se if they falsely accuse a person of a crime or if they infer to improper or incompetent conduct involving a person's trade, business, or profession. As outlined above, defendants have publicly accused plaintiffs of serious criminal conduct, most notably sex trafficking, tax fraud, forced labour, and operating a cult, all without supporting evidence or legal findings. Moreover, defendants admit that they met with the FBI and helped initiate an active investigation with Plaintiff Shin. On multiple occasions, defendants have stated as fact that Plaintiff Shin is the leader of sex trafficking and labour trafficking operation, asserted he's under federal investigation, and called for him to be imprisoned for life. Defendants posted that dancers' social media profiles directly benefit Shin financially and that continuing content creation would be the equivalent to committing crimes amid an FBI investigation, implying wrongdoing without evidence or formal charges. Moreover, defendants have repeatedly accused plaintiffs Miranda and James Derrick of participating in a fraudulent marriage, of being coerced and controlled, of funneling proceeds from brand partnerships to criminal enterprise led by Shin. Further, defendants have publicly accused plaintiffs of forging legal documents, including marriage certificates and tax returns, and deleting evidence to obstruct justice. Despite plaintiffs' discovery requests asking defendants to identify any individual with whom they communicated about these allegations, defendants have failed to disclose any sources. Defendants' attacks are not merely defamatory. They strike at the heart of plaintiffs' professional reputations and income streams, because the false statements alleged here accuse plaintiffs of serious crime and call into question their honesty and fitness in their respective professions. They are defamatory per se. Therefore, the third Dalberg factor strongly favours granting a temporary injunction. Then they're saying they've got likely to succeed on their tortious interference claim. And again, you'll find that a lot of stuff is repeated because they cover several different, they do cover several sections. Again, what are your thoughts on this? What are you thinking about it all? It's very detailed, as I said, it's very detailed, very specific. They've outlined, they've given that that it's always, you always give the information and then with a, all right, let's have a look. Yeah, so that, yeah, we've got the memorandum. We'll go to the affidavit next. We're nearly done with this. Plaintiffs are also likely to succeed on a tortious interference of contract claim. To prevail, plaintiffs must show existence of contract, the alleged wrongdoer's knowledge of the contract, and intentional or procurement of its breach without justification and damages. Here, the defendants have actively and publicly urged third-party brands, such as Drink Prime, to sever ties with plaintiffs by associating them. Defendants falsely claimed that plaintiffs were involved in criminal conduct and that influencer revenue was funneled to plaintiff Shin as part of a trafficking scheme. Defendants also declared that continued brand partnerships would be, these efforts, along with the broader defamation campaign, have led to reputational harm, the loss of brand deals, and the decline in plaintiffs' professional opportunities, all central elements in a tortious interference and defamation claim under Minnesota law. Accordingly, the record strongly supports plaintiffs' claims, and this factor weighs in favour of injunctive relief. You think that they'll grant this motion with conditions short order? It's going to be interesting. And Michelle says she's continuing to post too. The judge is going to be shaking her head in split. There's no reason why on the day of court the plaintiffs don't go, and here's what's been posted since this. As I said, we haven't seen their reply. I believe that there's been a reply made. There's been a reply. There's been a memorandum. So there has been a reply, I believe. So I'll be interested to see. I'm interested to see in the justification of this, actually. All right. They're likely to succeed on their commercial defamation claim. All right. So here, defendants have repeatedly and publicized accused plaintiffs of operating criminal enterprise under the guise of a business and religious organization, asserting claims of sex trafficking. It's forced labor, tax fraud, and financial coercion. Defendants have also contacted or tagged business partners such as Drink Prime in their social media posts, urging them to sever ties with plaintiffs based on these false allegations. Such statements not only attack plaintiffs' personal character, but go to the heart of their professional reputation and commercial relationships, triggering the presumption of harm under the doctrine of commercial defamation. So then they've said about negligence per se. They start off by talking about what the standards are going to be met, and then they're repeating again about the guilty of crimes. I'm just sort of going to skip through some of these because they're repeating themselves, okay? This is the deceptive trade practices. Again, they've set out what needs to be proven and then why, how they've done it. For example, defendants tagged Drink Prime, a brand partner of the plaintiffs, and publicly urged the company to sever ties based on these false allegations. Okay, prospective advantage. Again, they've outlined that. Here, the plaintiffs have an ongoing and reasonable expectation of future economic benefit from brand partnership sponsors and business collaborations. Defendants are well aware of the opportunities he referenced plaintiffs' commercial relationships in numerous social media posts and videos. So they're talking about the harm and public policy. It says, while the temporary injunction may restrict defendants' speech, the right to free speech is not absolute. Individuals do not have a right to speak or publish without responsibility. Whatever one may choose, or an unrestricted, unbridled license gives immunity for every possible use of language and prevents the punishment of those who abuse this freedom. In other words, individuals do not have a right to say, or this case in point, whatever they like at the expense of others. Although not binding, a persuasive Minnesota District Court opinion found that public policy supports enjoining a party from posting online content about the opposing party. Here, the defendants have launched an extensive ongoing campaign of public accusations, claiming that the plaintiffs have engaged in, and they've listed all of that. Defendants have actively encouraged federal indictment, pressured brands, cut and sever ties, and accused the plaintiff's legal counsel of criminal behaviour. And that's a really serious allegation as well. This type of unchecked conduct undermines the justice system, promotes misinformation, and inflicts reputational harm without recourse. The public interest is not served by allowing a party to use online platforms to interfere with ongoing litigation or destroy another's livelihood and reputation through defamatory campaigns. Indeed, public policy in favour of maintaining the integrity of legal proceedings and protecting individuals from reputational destruction through false inflammatory statements. Therefore, the fourth factor. And then the administrative burden. And it does say it's going to be a big burden. Granting plaintiff's request would not impose any significant burden as relief sought does not require affirmative performance or ongoing detailed oversight. As done in the Minnesota District Court, the injunction would simply require monitoring the defendant's social media platforms, which could be conducted by the parties in this action. Additionally, because the injunction would remain in place until final adjudication, this action, any administrative obligation imposed on the court would be minimal and temporary. And then it says that's the rest. So that was the motion. Okay, so now we get to her affidavit. All right, that took a while. Sorry, as I said, it's just there's a lot of stuff here. So let's look at her exhibits because I imagine they're going to be pretty extensive. This one's 5 pages. So this, let me just get rid of this. Okay, so what they've done is they've just put in copies of, so there's 5 pages here. So this is just the titles. So we've got all the exhibits. So, and they're Instagram posts. So then we've got affidavit. Yeah, that was 5 pages. Right, here we go. We're going to go to the big one. It's an exhibit list. It's 33 pages long. I think she does write, and that wouldn't surprise me that if she writes a lot of her legal stuff. I'm actually wanting to see the response to this because I don't know how she responds to her videos. Is she going to sit there and say that that everyone's been wrong? There you go. So here's her exhibit list. And the transcript. And the transcript of what's been said. It's been transcribed. Look. It's all been transcribed. And then there's this one. Again, transcription. This changes everything I just won. And the court made. So one of the things the court doesn't like is people saying that they got it wrong. I am screaming from the rooftops. Finally, law enforcement has heard our pleas and cries. I don't believe anyone was arrested. I mean, taking somebody into custody and arrest are two different things. You can be taken in for questioning and be released. Just because you're going to have a friendly chat to a police officer or an FBI agent doesn't mean anything. And again, here we go. Video transcripts. So it's all here. And look, she says here, Shinny's not the brightest bulb. I'll be with you in a minute. I'm just going to have Harrison FaceTime me for a minute. I think he's trying to ring me because I think he's at the footy thing today. So there's that one. That was, and then we've got exhibit list 79 pages. So they're big pages. You know, I'm not going to go through everything because it's not worth it. No one was arrested. Actually, if KJ hadn't put her face out, no one, well, that's right. No one would have cared or known. You are right. So this, I believe, is the next one. So they've just got all the exhibits here. Again, marriage license, you know, they have just been scanning her social media. They've been scanning her social media posts, haven't they? Oh, wait on. I've done that one. Done that one. No, that one says 79 pages. Okay, so we've got to download this one. Yeah, there's a lot of documents here, so it's getting a bit confusing. I'm confusing myself here with what I've done and what I haven't done. Download PDF. Here we go. Yeah, no one was arrested. That's right, and that's the thing. Nobody's been arrested. Just because you go in for a chat doesn't mean that you. Oh, hang on. Yes, Harrison.
Look at the badge I got.
Harrison was just telling me he'd been to the Family Fun Day at the MCG because big footy grand final. It's like your Super Bowl thing. It's like a big thing, and he's just telling me all the players that he got to see. Anyway, so then they're the case laws that they're the cases that they're relying on. All right, so then we've got affidavit of plaintiff, and so that's all of Amber's case. So this is an affidavit of from James Derrick. As the date of this filing, no criminal charges have been made against me related to defendants' statements. I deleted my social media presence as a result from backlash from defendants' increased aggression this year. That's all he said. So he's sworn an affidavit. He does sound like he's having fun. He's had a great time. They're leaving because the lines are really long. But they're back in the city tomorrow because it's the grand final parade tomorrow. And so they're going back again tomorrow. He was really excited because he's got a badge of the Brisbane coach. So, yeah. All right, so this is Miranda Derrick. So that there's been no criminal charges. I delete my social media presence. So they're saying they've released, they have deleted their social media because of the actions of the increased pressure. I mean, every time they posted something, they would get all of this other stuff here. And then this is Robert Shin. Saying that as of date of filing, no criminal charges have been made against me. So again, in you are innocent until you're proven guilty, and it would seem that, you know, you can't say that he's a criminal. I mean, you can say that there's accusations or all stuff, but you can't say that somebody's a criminal. So there's some more. This is where she could see discovery Robert Shin provided me in court showed forged taxes, marriage licenses. It proves Miranda Derrick has no control. As I said, she could have breached some discovery rules there. And again, this is the fact that they put this in. So she said Robert's traffickers saying it's all a misunderstanding. It was either Matthew Young, but that's not even what it was about. It was the raid. The feds got him. Oh, so do you think she's actually helping her case here at all? Or do you think she's making it worse? Yeah. Yeah, so this is the 17th, this motion, this injunction is going to be heard. So then here is more. So they have just essentially grabbed her social media. Look at this. This should be hidden. They've got it all. And it's all now before the court. All right, this is a memorandum now from, yeah, I've seen some of the posts, and I know, well, she's not hurting herself. She's hurting her family, to be fair. I mean, it's her family that's going to suffer. Look, okay, so this is in response. So we're now back to the motion to reconsider. Okay, so when a motion is filed, you file a motion, the party gets to respond, and then you get to respond to that. So that will happen again with the other stuff as well. Is the defendant's reply. Okay, so this is their response to what all right, let's have a look. Defendants submit this reply in further to support their motion to reconsider the court's order, June 23rd order. Reconsideration is warranted here not because defendants disagree with the court's reasoning, but because the order permits claims to proceed in ways foreclosed by binding First Amendment precedent. Plaintiff's opposition does not meaningfully engage with the constitutional issues set out in defendant's memorandum supporting reconsideration. Instead, it misunderstands the remit of Rule 115.11, misstates the governing law, and relies on rhetoric in place of authority. First, plaintiff the remit of this motion. Rule 115 permits reconsideration where a decision is palpably wrong. Defendant supporting memorandum explained that reconsideration is proper here because the court's order deferred threshold constitutional questions to a jury, treated implications as actionable, and diluted the actual malice standard. Plaintiff's opposition does not address for remit. Secondly, plaintiff's memorandum walked through controlling precedent. Milkovich, Jardwin, Anderson, Triflulis, Claiborne, Hardware, and Boss. Plaintiffs cite none of these cases. Instead, they rely on procedural authorities about new arguments and an unpublished decision, Finn, that has no precedential value. As already explained in defendant's memorandum filed August 15, the arguments at issue were raised in the summary judgment briefing and then clarified in light of the court's ruling. So Keto says she has been the nightmare that doesn't stop for Robert and the Derricks. I would like them to receive everything that they have asked for. Well, I think a temporary injunction would be warranted. Or the judge was to put in a suppression order, which means that no media could speak about the allegation. When they say the suppression order, okay, if if there were charges filed, that would be newsworthy, but it's not newsworthy to give opinions as facts. And so that's what so for example, if there were charges filed, and that would be newsworthy and that could be reportable, but guessing or throwing darts on the wall as to why the raids occurred would be stopped. Third, the plaintiffs argue in bad faith. Their opposition accuses defendants of grandstanding and lying, but never grapples with the constitutional standards already laid out in defendants' memorandum. Adjectives cannot substitute for authority. Hostility cannot substitute for analysis. The court should use these tactics for what they are, an effort to obscure the absence of controlling law. For these reasons, and further developed below, the supposed errors identified by plaintiff in defendant's memorandum supporting reconsideration remain unaddressed. Correction of the June 23, 2024 order is necessary to ensure the constitutional standards are properly applied for. She's trying to get this thrown out, and if she can't, she goes before others. I don't think she has much of a hope coming out clean. I don't think she's going to come out clean, a short order. I think that's correct. I just don't know how much damage is going to be done in the meantime. Minnesota rule of general practice provides that the motions for reconsideration shall only be granted in circumstance. The advisory committee comments further explain that reconsideration is appropriate where a decision is palpably wrong in some respect. Defendants' initial supporting memorandum set forth how the court's order misapplied controlling First Amendment precedents in the way that are dispositive of plaintiff's claims. That is the very circumstance Rule 115.11 contemplates. The Constitution simply does not permit errors of this kind to be left for a jury. So they're still going down the free speech amendment rule and journalistic protection. Obviously, that's they're still putting all their eggs in that basket. In their opposition argument, plaintiffs mistake this standard in two respects. First, they argued that the motion for reconsideration cannot present new arguments, but the defendants have not introduced new facts or theories. Hang on, you did. You mentioned about the raids. Isn't that a new fact? Sorry. The arguments before the court are the same defences advanced in defendant's summary judgment briefing, clarified in the memorandum supporting reconsideration, when the court's ruling crystallised the constitutional errors. The only refinement addressed defamation by implication, a theory elevated by the court's order itself, identifying that constitutional flaw is not new argument. It is the very function of reconsideration. Secondly, rely on cases that do not control here. They cite American Bank versus Coding Specialty and for the unremarkable proposition that reconsideration cannot be used to submit new evidence. Again, defendants are not doing so. Plaintiffs also cite, Finn, an unpublished case with no precedential value and no relevance to the First Amendment constitutional error. Yeah, so they're relying on the First Amendment. That's where they're putting all their eggs. They will be in huge trouble if the eggs in that basket break. None of the authorities address the core principle at issue when an order fails to apply binding precedents on opinion versus fact, actual malice, or boycott advocacy. The error is not discretionary, it is constitutional, and reconsideration is required. By reframing reconsideration as a procedural game, plaintiffs ignore the substance of the rule and the authorities that govern here. The court has the duty to correct constitutional missteps before trial. That duty is what defendants invoked in their supporting memorandum, and plaintiffs' opposition offers nothing to contrary. Plaintiffs' opposition repeatedly asserts that defendants are raising new arguments on reconsideration. The record shows otherwise. Hang on, what record? You went on about how there was a whole section in there about the raids. Each issue identified on defendant's motion was presented in defendant's summary judgment briefing and then further explained in the memorandum supporting reconsideration when the court's ruling crystallised the constitutional errors. Defendants argued in their summary judgment memorandum the terms such as cult and hashtags like trafficking were rhetorical hyperbole and non-actionable opinion. The reply memorandum reiterated that the plaintiffs had failed to distinguish fact from commentary, emphasising the role of context. Defendants expanded on this argument only because of the court's order deferred the threshold legal question of opinion versus fact to a jury. That is not new argument. It is the correction of constitutional error. Now, one of the things that could happen here is the judge may then make her own decision. So they're arguing that a jury shouldn't be left to make those decisions. What's going to happen if the judge says, yes, I've reconsidered it, and your hashtags are factual, and therefore you've defamed them? What are they going to do then? Anyway. Defendant's summary judgment briefing explained the plaintiffs had no evidence that Ms. Paulson subjectively entertained serious doubts as to the truth. And the reply memorandum reinforced this point. The reconsideration memo also addressed the court's conclusion that the plaintiff's denials sufficed to create a jury issue. The argument was not new. It became necessary once the order diluted the clear and convincing standard. Defendants argued at summary judgment that calls for a boycott are constitutionally protected and that any interference was justified under the refusal to deal doctrine. Again, not a new argument, but a response to the constitutional error. Defendants argued at summary judgment that Minnesota Statute 609 was unconstitutional and could not support liability. The reconsideration memo simply reiterated that point in light of the court's contrary ruling. So Michelle says, so real question, if someone were to say boycott someone else's channel, for example, is it okay for you to just say it's boycott advocacy, use a bunch of hashtags saying whatever you know? Well, that's what she's essentially saying, Michelle. That's essentially what she's saying. The only refinement was to address plaintiff's reliance on implication as a theory of defamation. Defendant's reconsideration memo explained why implication alone cannot confer liability under Milkovich and Jadwin. That refinement was necessary only because the court's order treated implications as sufficient. Correcting that constitutional error falls squarely within Rule 11511. In short, plaintiff's opposition does not demonstrate that defendants raise new arguments. It demonstrates only that plaintiffs have chosen not to engage with the record. The arguments were briefed, cited, and developed. The court's order revealed why correction was necessary. The only new material in this case is the rhetoric in plaintiff's opposition. Oh, hang on a minute, but they talked about the raids and everything in her stuff. Now they're trying to say that it was the plaintiffs that brought in new information. Do they not read what they write, what they submit? Plaintiffs contend that most issues raised in defendant's motion should be left to a jury. That argument misunderstands the court's constitutional responsibilities. In defamation cases, the Supreme Court and Minnesota courts have imposed specific gatekeeping duties on trial judge. These threshold determinations cannot be delegated to a jury. Whether a plaintiff is a public official or public figure is a question of law for the court. Here, plaintiffs' roles as social media influencer, entertainment manager, and leader of the church at the centre of public allegations make their status as a threshold legal question and must be resolved to the court. So theoretically, one could essentially find themselves jobless. To be so foolish to risk it. Yes, Michelle. So, but then we get to the question whether a social media influencer, entertainment manager, and leader of a church at a centre of public allegation. But does being a church leader make you up? Here's the thing. This could create precedents as well. Is a social media influencer a public figure? Is an entertainment manager a public figure? Is a leader of a church a public figure? Interesting. When challenged statements are actionable statements of fact or protected opinion, is likewise a legal question of the court. So again, they're going down the protected opinion route. Rhetorical hyperbole and figurative language, including hashtags and commentary, cannot be submitted to a jury as though they are provable facts assertions. Finally, the court must determine whether plaintiffs have presented evidence from which a jury could reasonably find actual malice by clear and convincing proof. This is not fact-finding. It is a constitutional safeguard to ensure weak or conclusory allegations do not proceed to trial. Together, these gatekeeping functions ensure the defamation claims proceed only when constitutional thresholds are satisfied. Plaintiff's opposition seeks to collapse those duties into jury questions. This is not the law. Issues raised in defendants' motions fall squarely within the court's non-discretionary responsibilities. The court has a duty and the authority to correct these errors now. Respectfully, the defendants ask that they do so. So it is quite possible, though, that the judge turns around and says, "Well, yes, they're not public figures. You are not a journalist. You are not protected by this." And her whole case will just fall down. What I will say is that there has been no response as yet to that that I can see to the injunction. So just we'll let you know that that there's been no Again, there's something interesting here. So anyway, so the court's order concluded that the jury could treat Ms. Paulson's commentary and hashtags as actionable factual assertions. Defendant's reconsideration motion explained why that was a constitutional error. Whether a statement is fact or opinion is a threshold question of law, not an issue to be referred to a jury. I mean, this could backfire on them. The judge may make these decisions, and it could be worse for them. Defendants raised this issue in their summary judgment briefing. They argued that references to just trafficking were rhetorical shorthand, not provable factual claims. The reply memorandum reiterated that plaintiffs had failed to distinguish between protected commentary and actionable statements. Plaintiffs' opposition ignores those citations and instead repeats that the real issue is factual. That mistakes the law. Minnesota courts have long recognized that rhetorical hyperbole and figurative language are not actionable because they cannot be proven true or false. Social media hashtags, by their very nature, are not carefully drafted factual assertions. They function as shorthand to frame a subject of discussion. To treat trafficking as equivalent to an express criminal accusation is to conflate commentary with fact. Precise errors Milkovich has forbids. It's going to be interesting how they deal with this hashtag question in her posts where she's made those accusations. Plaintiffs cite no controlling authority to the contrary. They rely instead on procedural cases about new arguments and ignore constitutional gatekeeping duties. By doing so, they seek to shift the court's responsibility onto a jury. This is not law. Correcting the error in the June 23, 2025 order does not expand the issues before the court. It reinforces what defendants already argued at summary judgment and clarified in the reconsideration memorandum. The threshold determination of opinion versus fact is for the court. Plaintiffs' refusal to engage that principle underscores why reconsideration is necessary. The court's order treated plaintiffs' denials of defendants' reporting as sufficient to create a troubled issue of actual malice. That conclusion was a constitutional error. The Supreme Court has made it clear that public figure status is a threshold determination for the court, not a jury. Minnesota courts have followed the same rule. Here, the record leaves no doubt. It would be impossible to report on the Wilkins family's public allegations without also reporting on Robert Shin, Shekinah Church, and 7M Films. By their own conduct, these plaintiffs were at the center of an ongoing public controversy. The Derricks are nationally known by social media influencers with millions of followers, monetizing their image through brand partnerships. They voluntarily built their careers on publicity. Robert Shin and 7M Films promoted themselves publicly as a religious and management enterprise, negotiating contracts and courting brand deals. Even plaintiffs' own briefing concedes that if plaintiffs alleging defamation is a public figure, a heightened standard applies, and that Paulson's conduct would meet the burden as if they were public figures. Plaintiffs cannot acknowledge the standard while disclaiming the status. Once they are public or limited purpose public figures, they plainly are. Only permissible standard is actual malice. Interesting, because usually you're always right. Like usually it'd say we deny all allegations, and even if the allegations of defamatory were true, we would still have our defense. That's usually what you always write. It's like a get out of jail free card. So they're saying, yes, we meet the burdens. However, even if there was the burden of public figures, we still believe. It sounds like they are re-arguing their case using additional information. Not really. No, they haven't really answered the plaintiffs. You're correct. The actual malice and demanding liability may be imposed only if a plaintiff proves that the defendant published a statement with knowledge that was false or with reckless disregard of whether it was false or not. Common law malice, ill will, hostility, or financial motive is not sufficient. Defendants argued at summary judgment and explained it again in their reconsideration memorandum. Plaintiff's opposition does not engage with this standard. Instead, it points to Miss Paul and her desire to see Mr. Shin held criminally accountable. That is not evidence of actual malice, and at most, it is evidence of common law malice, which the Constitution forbids as a purpose of liability. The clear and convincing burden applies at summary judgment. The court must determine whether plaintiffs have presented evidence from which a reasonable jury could find actual malice by clear and convincing proof. Plaintiffs offered none. Their depositions consist of denials. The defendant's reporting was not true, but the plaintiff's disagreement with reporting is not evidence of the defendant's subjective state of mind. There is no document, no admission, no testimony showing that Miss Paulson subjective state of mind. There's no document, no admission, no testimony showing that Miss Paulson believed her reporting was false, had serious doubts about it, nor is there evidence contrary to her reporting. Didn't she actually put in one of her things that her reporting was wrong and she corrected it? The judge has already seen with her own eyes all these years of nasty, malicious drunk videos. She's witnessed the behavior now and has said that the jury would decide utter carelessness, in my opinion, says Musha. Hello, Tammy Sue. By treating bare denials as sufficient, the court inadvertently reduced the constitutional standard to credibility contest. That is there was a footnote here. Was it about common law malice? Oh yeah, there's the one. It says even if common law malice, such as ill will, hostility, or financial gain, were a factor, that plaintiffs have presented no competent evidence of it. Miss Paulson had no personal connection to Mr. Shin. Her reporting was based on publicly circulating allegations, and her conclusion that he behaved like a cult leader reflects her interpretation, not malice. Allegations that she earned money from her reporting or wanted plaintiffs held accountable are neither legally sufficient or factually supported. Indeed, well-settled law confirms that publishers' profit motive without more cannot establish actual malice. Common law malice is not constitutional actual malice. Right. The court allowed plaintiffs' negligence per se claim to proceed under Minnesota Statute 609, Minnesota's criminal defamation statute. Defendants' reconsideration motion explained why this was a constitutional error. Permitting the statute to operate as negligence per se would allow plaintiffs to recover without satisfying actual malice. That end run around Sullivan is constitutionally impermissible. Negligence per se requires a valid statute that defines a duty. The statute does not qualify. Criminal defamation statutes have long been subject to strict constitutional limits, and Minnesota courts have recognized that 609.765 is enforceable only in narrow circumstances, if at all. To use it as the base compound these constitutional infirmities. To be fair, can anyone legally understand KJ's mind or what she's thinking? Well, that's a good point. The Supreme Court has made it clear that criminal defamation laws cannot be applied in ways that dilute constitutional protections. Here, plaintiffs seek to repurpose the statute as a negligence per se standard. This would permit liability without proof of actual malice. The very result times a New York Times versus Sullivan and its progeny forbid. Plaintiff's opposition does not identify any Minnesota or federal decision holding that the statute may be used as the foundation for negligence per se. The absence of authority is telling. Negligence per se is a narrow doctrine which cannot be used to bypass First Amendment limits on defamation claims. Plaintiff's September 5 letter underscores the discovery concerns defendants raised through this litigation. For more than 18 months, plaintiffs ignored this court order requiring disclosure of information. On the very day their response to the instant motion was due, plaintiffs finally produced much of the information defendants had been seeking. Their transmittal letter, however, accused defendants of discovery misconduct and threatened sanctions. That position speaks for itself. Because plaintiff's production occurred long after the close of discovery, defendants may still seek sanctions and the opportunity to reopen discovery in order to dispose plaintiffs' employees responsible for bookkeeping and financial records, the plaintiff's tax accountants, and his files. As an additional motion may be necessary, the court need not address sanctions in this context of this motion. For its present purposes, plaintiffs' accusations provide no basis to deny reconsiderations. If anything, they confirm a pattern of obstruction that reinforces why constitutional thresholds must be applied. The court has a duty and authority to correct these errors now. Respectfully, defendants asked to do so. Plaintiff's opposition does not meaningfully address the constitutional errors identified in defendants' memorandum supporting reconsideration. Instead, it relies on rhetoric and accusations while avoiding controlling precedent that governs this case. The court's gatekeeping duties are clear to determine as a matter of law whether plaintiffs are public figures, whether the challenge statements are fact or opinion, and whether plaintiffs have produced clear and convincing evidence of actual malice. On each point, plaintiffs have failed. They are public or limited purpose public figures, and their status is a threshold legal question, not a jury issue. The challenge statements are rhetorical hyperbole and opinion, not provable factual assertions, and plaintiffs have presented no evidence, let alone clear and convincing evidence, that Miss Paulson knew her reporting was false or that she harbored serious doubts about it. Plaintiffs' remaining claims fare no better. Tortious interference cannot be based on a constitutionally protected advocacy, and negligence per se cannot be founded on criminal defamation statute that the First Amendment does not permit to be used as a civil duty of care. In short, the new material here is the rhetoric of plaintiffs' opposition. The controlling law has not changed. While it's become clear that the court's order permitted claims to proceed on grounds foreclosed by Sullivan, Milkovich, Anderson, Rosenblatt, and NAACP and their Minnesota counterparts, correction is not optional, it's constitutionally required. For these reasons, and for those stated defendants' memorandums supporting defendants respectfully ask the court to grant their motion, reconsider its June order in its favour on all claims. Right, so then we've got her affidavit. We're nearly done here. I might come back for a part 2 because I think we might look at the continued social media stuff. I might come back later today. So this is her 7th declaration. Exhibit 1. So she's talking about the letter. It says, Miss Moore, you've made numerous allegations that the plaintiffs have failed to comply with discovery requests. Despite this, you've failed to send plaintiffs a discovery deficiency letter with the requests for discovery. The only correspondence in plaintiff's possession is a letter dated June 6, 2024. This letter berates counsel for not having the authority to schedule depositions with persons who are not our clients, degrades counsel's medical history, states a vague refusal to comply with discovery demands without specifying which demands, makes odd references to a Netflix documentary your client was an informant on, and demands plaintiffs dismiss their lawsuit as they're not serious about litigating this matter. This letter is incoherent, inflammatory, and wildly unprofessional. Rather than raising legitimate discovery concerns, it devolves into speculation, unsupported accusations, and irrelevant commentary regarding media coverage and third parties who are not part of this litigation. This type of rhetoric is entirely inappropriate in the context of professional legal correspondence, specifically as a purported discovery demand letter. Further, this letter does not refer to any discovery requests or requests specific documents. It requests plaintiffs dismiss their lawsuits. To be clear, our clients have complied with their discovery obligations under Minnesota rules of civil procedure, including the timely production of materials responsive for your requests. If you believe that specific documents remain outstanding, it is your responsibility to identify the discovery request you believe to be outstanding. We are unable to ascertain what you believe the plaintiffs have failed to provide, as you have merely made vague demands and accusations. We are committed to addressing legitimate discovery issues. However, it is not a professional requirement to allow defendants to threaten or degrade plaintiffs or their counsel through purported discovery correspondence. Continued lack of civility in litigating this matter will be met with a request to the court for sanctions. We welcome any professional discovery requests and have attached the items we believe defendants are attempting to obtain. These documents are for attorney eyes only. However, we do not understand what discovery demand defendants are requesting, as no request for the same has been made. Should the attached documentation not be what you're attempting to obtain through discovery, please send a professional letter limited to discovery requests the same. Wow. So they have said that they have attached what they think they were asked for. I love Amber. She's got style. She's yes, that's right. Wow, what a letter, hey? Is that is that to the judge? Oh, they're being mean to me. So the so taken under advisement is the reconsideration. Then we've got the notice of hearing, which is the motion hearing. And yes, I am going to make the assumption, because the reconsideration is under that's under advisement. Okay, this is the hearing, so it's at 3 p.m. It is a notice of hearing, and it looks like it's in person. So it's at 3 p.m. on October 17. Okay. Now, so as far as I can see, taken under advisement, because remember, this was the final memorandum. So that was for the reconsideration. Normally, there would be a notice of decision. So there's no notice of decision. So this notice of hearing would be for the sanctions. That's really that's my understanding and my belief. So the hearing. So let's have a look, because they would have had to have paid for that motion. Here we go. Yeah, $100 for that motion. They both filed motions. Oh, she filed another one. So the 18th of the 8th, oh no, that's 18th. On the 19th of the 9th, she paid, Catherine paid another $100. So there must be more coming. Oh, so it was reset by the court. It was supposed to be 130, but it's now. Oh, wait on. Yeah. Yeah, that was the motion. So yeah, so this is a motion hearing. Yeah. So there you go. So that we are up to date with all the court documents now. I'm a bit confused as to their response. I'm a bit confused to the response to the stuff. I have to say I found it all a bit confusing and all a bit over the place. But what about Amber's letter? Imagine, I mean, no wonder they're upset with her. Oh, I'm just having a look at their Instagram. Oh, no. I was interested. There was another from KJ. So look, I'll have another look. Did she respond? To affidavit, exhibit list, affidavit of plaintiff, other document. That is more of that. That's the memorandum. That's the affidavit. I can't see it. I'll have to have another look. If I find it, I will have another look. As I said, I haven't seen it, but look, I could have missed it. There were a lot of documents there. I left it too late, really. I saw that she's made a lot of comments about Erica Kirk. KJ, she sent a letter, did she? Well, that doesn't mean that it's in the court file. Just having a look. Miss Balls has probably got it. Oh, yeah, here we go. Oh, this has probably been because this is the letter. Oh, okay. So, as I said, Oh, really? Answer to injunction? So, but I mean, that hasn't been... She may have shared it, but it's not in the court file yet. So I'm not saying... So, oh! All right, let me read this to you, okay? So this was served by eServe, September 23. Miss Stavag, pursuant to Minnesota R Civil P 113, this letter serves as a formal notice that unless plaintiffs withdraw their pending motion for a temporary injunction within 21 days, defendants will move for sanctions. The motion is sanctionable for multiple reasons. Unconstitutional prior restraints. Plaintiffs ask the court to enjoin Ms. Paulson from making public statements about them. Such relief is a classic prior restraint, which Supreme Court has repeatedly condemned as the essence of censorship. Minnesota courts have echoed this prohibition. Injunction is not available to restrain the publication of defamatory matter. An injunction against defamatory speech constitutes an impermissible prior restraint on speech. Any prior restraint on expression comes to court bears a heavy presumption against constitutional validity. This court has already denied plaintiff's first motion for an injunction for a temporary injunctive relief in 2023, repackaging that failed request with no new facts or law is not zealous advocacy, it is wasteful. What? Didn't they just see the hundreds of pages that they filed? Did you see where she posted a pic of Jennifer and said she wrote it under Katie Joy Post? No, I didn't. The timing and scope of plaintiff's request further reveal its lack of merit. Plaintiffs filed this extraordinary motion while defendants' motion for reconsideration of summary judgment is pending, compounding burden without advancing substance. Even more telling is what the plaintiffs have not done. They have never sought a retraction or correction of the very July-August 2025 posts they now justify emergency relief. Their affidavits did not identify these posts, having tolerated years of reporting without objection and having, until this motion, ignored the specific content they now target. Plaintiffs cannot credibly claim imminent irreparable harm. Urgency that materializes only when convenient for motion practice is not urgency at all. The affidavit submitted in support of the motion illustrate its hollowness. Each consists a little more than the assertion that no criminal charges have been filed. That truism, while unsurprising, does not establish falsity, malice, or irreparable harm. It adds nothing to the constitutional analysis. Miranda and James Derrick further state they deleted their social media accounts due to professional backlash. But the harm is neither new or tied to the July-August posts. It is simply a continuation of the reputational consequences plaintiffs have faced since they chose to bring and prolong this litigation. Harm that is cumulative, self-inflicted, or untethered to the content of the present motion cannot justify censorship if it is the strongest evidence plaintiffs can muster in support of the most disfavoured remedy in constitutional law. The motion speaks for itself. The motion is not about preserving judicial process. Plaintiff's own memorandum confirms it is about silencing commentary on matters of public concern. Filing serial injunction motions to harass defendants to relitigate issues already rejected by this court and to suppress ongoing public debate is the very definition of an improper purpose under Rule 11B. Plaintiff's motion is frivolous within the meaning of Rule 11. It recycles relief that this court has already denied, rests on affidavits that add nothing of legal substance, and demands the most disfavoured remedy in constitutional law without new facts or law to support it. Plaintiff's selective, belated focus on the new July-August 2025 posts only underscores the tactical nature of their request. Unless withdrawn within 21 days of service, defendants will move for sanctions, including attorney fees incurred in responding. But they were the one that brought up. She was the one that brought up the whole point of the rates. So, and don't forget, under the penalty of perjury, Miranda says she deleted her social media because of me, not because of a criminal investigation. Where does it say she did? It does not say I deleted my social media presence because of Katie Joy. It just said aggression. I have to say, I don't know what she said about that, but for me, that was, to me, that Erica Kirk, in my, for her to do that. Let's have a look at this. Blame anyone, she didn't blame anyone, not the left, not the right. She didn't express hate or anger. Erica didn't accuse Israel of killing her husband or what? Something that she made clear is that Charlie was an adamant proponent for freedom of speech. She reminded people that everyone has the right to speak, even when they don't agree. She doesn't want any more violence. I think everyone needs to respect Erica and stop promoting false narratives. So I am wow. I haven't been on her. If she didn't get a grip, the judge is going to have a say of her. I'm just gobsmacked at the amount of stuff on here. So I mean, I find it very interesting how they've sent a letter. They haven't responded to the motion. They could have just responded to the motion. That would have been better to me. Yeah, see, they've put in a protection order for this toilet so that people like her, and they're putting protection orders. They put in so he can't contact her. Gee, I was going to say that I think they need to also just some of those cases they like to also suppress some of the media or the media reporting on it just until because it's going to be, and he's entitled to just to a fair trial because that's a human right. Oh, look at this. I haven't seen these videos. I might have to come back later. We might have to do a deeper dive in this, but thanks to Miss Balls again for all her hard work. I don't know what I'd do without her. I'm 99% sure he has fake accounts making videos about me. It's been going on for years. Really? Is that right? Who is Robert Shin? Oh, yeah. You're like, nobody's caring, and that's the problem. So, yeah. I just find it interesting. It says, read the white text at the top. It says, let Katie Joy go after church or the Shins, but make it known she can't come after your daughter. Well, that's right. It's saying that she's the victim. I mean, and that they're doing all the stuff. Yeah. So as I said, I don't know. What is he currently arrested for? Do we know yet? And she says this is sex trafficking ring. Really? Yeah, well, that's right. We won't stop fighting for you, Miranda, apparently. Oops. Need to go back. Oops. I clicked on the wrong thing. Well, now Candace Owens is going after her. As of today, September 23, 2025, we are fighting for Miranda Derrick. In a recent court filing, Miranda Derrick's attorney filed an affidavit that accused me of aggressively attacking her and causing her to delete her social media. A rambling motion for a temporary injunction was filed against me by Robert Shin, Miranda, and James Derrick. I wouldn't have said it was rambling. The document paints my reporting as though I'm committing a crime by publicly reporting on a federal raid that was highly publicized and included multiple federal agents. Federal agents released a statement confirming a multi-agency federal investigation into Robert Shin and his associates related to sex trafficking, human trafficking, mail fraud, tax evasion, and more. Is that true? I've not seen anything to see that there was a statement made. Robert's attorneys filed a motion to stay discovery in California and told the court that Robert and his associates may incriminate themselves if they are forced to sit for depositions. Attorney Daniel Guttenplan told the judge the following: 5 search warrants were executed on 5 properties. The search warrants confiscated all electronics, computers, phones, and documents. Days later, a U.S. attorney subpoenaed Robert and others to appear before a grand jury. there is a reason to believe that Robert and associates could be indicted immediately. So, well, he was, as far as I know, he wasn't present at the raids, was he? And again, just because they did a raid doesn't mean they're going to find anything. No statements made, just news reporting that there was. I've only seen stuff about a raid. I haven't seen. Oh, News Nation. I'm just having a look here. News Nation was saying alleged. Allegations against LA if they call the journalist Katie Joy, oh no. Guess who? Allegations of LA pastor are tip of the iceberg journalist. Guess who the journalist is? A federal and law enforcement raided the homes of LA pastor and talent agent Robert Shin. Investigative journalist Katie Joy says allegations leveled at Shin are tip of the iceberg. Joy joined Bay Manfield on Tuesday night to discuss the warrant was issued amid allegations of sex trafficking, alleged tax evasion, money fraud, money laundering, and COVID-19 pandemic-related accusations, according to the news affiliate. This is a long time coming. This is just the tip of the iceberg. At least 6 people were detained with handcuffs, but police did not immediately say whether anyone they were to arrest. Joy also alleges Shin has changed his name. So notice that they always say alleged. Yeah. So it looks like, as I said, other than the fact that as soon as I see Katie Joy's name with an article, I sort of go, I don't know if I can really trust that. So it does say it's a part of a money laundering and sex trafficking investigation. But still, again, it's an investigation. It doesn't mean that they're guilty. I mean, it could be that they've had complaints and they're investigating it. Trafficking, apparently, allegedly. See, Melanie Lee says we've been dreaming about this day. But again, you're done on tax fraud doesn't mean that you're guilty of all those other things as well. Let's just face it, you know. All right, thank you for joining me. It's been a big day. Well, that's right. Nobody knows, and that's the thing. It's speculation, and this is where I'm saying she could possibly get reckless disregard for truth because she's taken whatever it said and she's run with it, and rather than just saying it's been raided and people were detained all the time. As I said, they could be helping with the investigation. You know, doesn't mean that they're guilty or they've been arrested or anything. Even being arrested doesn't mean that you're not, you know, anything. So we will wait and see. I've got to come back. I want to talk about I've got to do an update on Reynolds and Higgins. I've got to do some, so hopefully in the next couple of days. And who made those complaints? Isn't Melanie? Yes, Melanie Lee's trying to sue. She's got a she's suing Shin at the moment. That's right. That court is going. That's happening at the moment as well. So you've got to always remember what the source is. And very interesting. So so I've got an eye appointment later today, and I've been working with a personal trainer for week 5, I think, working with a personal trainer. So I'm starting to feel good. I'm currently on holidays at the moment. Can't believe the first week's nearly done. So I'll try and get on tomorrow. I'll try and get on later tonight, and then I'll probably get on tomorrow, hopefully, and just have a hangout and chat. And all right, I'll catch you next time. Thank you all for joining me. Please make sure you hit like and subscribe. It would be great. Hopefully I can be a little bit more regular coming up. All right, I'll catch you later. Bye for now.